Now going to introduce Stephen Keim SC to give us a talk about the future of the CMC. Give it up for Stephen, people. Come on.
Well, what a terrific audience you are. I recognise some of you, but I guess what's really good is the fact that there's a lot of people I don't recognise. I've basically been underwater for the last 6 weeks, and so I'd really like to have a nice little instructed speech. I did have one for Palm Sunday on the same subject. And it actually rained all day on Sunday.
Could you just speak up a little
Okay.
bit, please? Sorry.
Okay, I'll come a bit closer as well. It actually rained on Palm Sunday, so I did deliver this beautiful speech to about 5 people. 5 hardy people. And so I'm going to work from those notes. And the only problem with that is that all the jokes are about palm trees and donkeys. So if I say something that's inappropriate to today, that's because I'm reading the wrong notes. I've also I've got some notes that I was contributed to the Bar Association's submission with regard to the changes to the CMC legislation. And so, like you got saying, the association this and the association that, you'll know that there's a problem. But it's in the notes, not necessarily in my head. The situation with regard to these changes is that they've gone through Parliament, but the bill hasn't been assented to yet. So it's not actually an act yet. And what I'll come to at the end is that the issue of staffing the new commission will be quite important. So there will be a lot of politics associated with that. And that's partially due to the fact that there was one change. I'm told there's one change. I've been underwater, as I said, so I actually haven't got to read the bill as it currently stands after its third reading speech. But the one change is to the way in which people are appointed. Now, I guess that's what all the debate was about, but there are a lot of aspects of the changes to the CMC, which will be the CCC, the Crime and Corruption Commission. And you get an idea of this if you read the committee report, because the Bar Association and the Law Society and a whole lot of academics and people who've been part-time commissioners before, lots and lots of people made submissions. They went through the bill very carefully. You've got a lot of different parts of it that where the changes are in the wrong direction, they're unsatisfactory. So if you want to have an idea of what's wrong with the bill, you get the report of the committee, you just go through with a black pen, and you cross out all the bits where it says the committee says, and you just read the bits where the staff of the committee put together the submissions and what were in the submissions and summarise all of that. You get actually a good feel for it. So if you can read it with sort of one eye shut, that's a really good idea of getting to the top. That's a really good way of getting an idea of what it's about. And as Joe said, in a one-house parliament, in a state where governments often win by a lot, where developers aren't banned from making political donations, the importance of an anti-corruption body, an independent anti-corruption body, can't be overstated. And so the fact that these changes will take away that independence, it's a matter of great concern. So let me start. Tony Fitzgerald QC presented his report on the 3rd of July 1989, almost 25 years ago. The report had been more than a year in the making. It's easy to underestimate what a watershed that report was in Queensland political history. The report confirmed what many had long suspected, namely that Queensland politics and the Queensland Police Service were rife with corruption. The report led to many prosecutions, a significant number of convictions, and a famous hung jury. Importantly, the report recommended systemic change to the way in which the Queensland polity operated and a number of institutional changes. One of the more important institutional changes was the creation of a strong and independent anti-corruption agency. And I think it is really important to understand the history for those who haven't lived through it, because it's only when you know the history can you understand how important the anti-corruption body in Queensland has been and will be in the future. That agency, which was recommended, became the Criminal Justice Commission. The Act to establish that body was passed on the 18th of October 1989 in what were the dying days of the National Party government led by Russell Cooper, a member for Roma. It fell to the Labor government led by Wayne Goss to establish the Criminal Justice Commission in 1990 after its election in late in 1989. The CJC, in an amended form and under the new name, the Crime and Misconduct Commission, survives to this day, but not for much longer. Now, the bill that is only waiting for the Governor's consent to amend the Crime and Misconduct Act, that bill is intended to change the nature of the institution so that it will no longer carry out its role as part of the Fitzgerald heritage. The CMC is a very powerful organisation. It has had bestowed upon it exceptional powers. These powers were bestowed because of its exceptional role to fight corruption and organised crime. They have grown over the 2.5 decades since 1989. The Commission was always intended to be independent of political partisanship, to have a degree of independence. It was intended to stand as a bulwark against the misuse of the institutions of the state for political or private advantage. Its independence was important for that reason. Its independence, to some extent, justifies its exceptional powers. That independence is to disappear as a result of these changes. The Commission's independence will no longer be ensured. The institution will be vulnerable at some time in the not too distant future to misuse and political control at the behest of the government in power. That loss of independence will mean the destruction of the safeguards put in place by the Fitzgerald report and the careful multi-partisan work of those politicians who caused the recommendations in that report to be implemented. And it really was, in fact, the mechanism of bipartisanship in appointments didn't come from Mr. Fitzgerald. He said that the Commission should be independent, but it was the three parties, the National Party, the Labor Party and the Liberal Party, who had the idea that you had to have support from at least two parties within the committee to be appointed. And so that bipartisanship survives until the present day, but will disappear soon. And it's the compromise with regard to that which is significant at the end. The compromise was that the one change, I'm told, that the government agreed to the bill was to give a slightly bigger role to the committee, and I'll come to that. Okay, there's four aspects I'll talk about, just to give you some idea of the different dimensions of the problems. The central one is this loss of independence, but all of these others contribute, and they aggravate the issue with regard to the loss of preventative role. Okay, the first of these concerns changes to the objectives of the Act. These changes flag that promoting integrity and prevention of corruption in the public sector are to be of reduced importance. This is done by changing the objective of continuous improvement of integrity and reduction of misconduct to simply the reduction of the incidence of corruption, and by treating this objective as of secondary importance. This is reinforced by the proposed change to Section 23, where the preventative function of the Commission now only relates to major crime and no longer relates to either misconduct or corruption in the public sector. Now, the effect of these changes will be that the loss of the preventative function will be downgraded. There will be less justification to engage in preventative activity, and importantly, money and resources will be directed elsewhere to the more sexy cops and robbers activity of the Commission and not to the preventative role. So that's one of the changes. It seems a minor change, but it is important. The second change I want to talk about is the criminalising of complaints. That is, if you're found to make a complaint that's not appropriate, then it becomes a criminal offence. And I'll just detail those changes for you. But the effect will be that people won't feel as free to make a complaint as they have been in the past. The second of my concerns relates to extending the criminalisation of people who get their complaints wrong. A lot of lay people are wrong-headed and mistake suspicion for evidence and legal activity for corrupt conduct. People should be encouraged not to be reckless in their complaints and to think carefully before putting an angry pen to paper. On the other hand, ordinary people should not be intimidated from ever making a complaint to the anti-corruption body because of the criminal penalties for getting it wrong. The proposed changes in the bill go too far. The existing 216 relates to complaints which concern frivolous or vexatious matter. Section 216 had a two-strike policy whereby a second wrong-headed complaint on the same subject matter may amount to a criminal offence. Also, existing sections 217 and 218 criminalise the provision of material that is false and misleading to the Commission as part of the complaint. The bill reinforces this by deleting vexatious and including it in the new offence. Section 217A makes it an offence to make a complaint in any of the following ways: vexatiously, not in good faith, for a mischievous purpose, recklessly or maliciously. And I think that's far too heavy-handed, and it will tend to deter people from making complaints. Now, everybody who read the bill for the first time, what they found really astonishing in this day and age is that throughout the Act, chairperson is changed to chairman. Now, I do recall that during the debate over whether Australia should become a republic, one of the arguments of the constitutional monarchists was that nothing would actually change. It was all a matter of symbolism. The point is, though, that symbolic changes in our public lives are important. The symbols of our lives tell us who we are, what we believe, and how we propose to act. That is why our public lives are infused with symbols. Flags, anthems, coats of arms, mottos, public holidays, soldiers lined up at football matches, statues and pictures on the wall, including the Attorney's office. The change to non-gender specific language in our statutes, and what other statutes are to follow this trend, and other public documents was important. It signified that as a society, we should no longer treat the female half of our population as capable of being overlooked and ignored. It signified that when a woman or girl made it to a position of public importance, it was not an exceptional event, but something that was proper, usual and ordained. And that sort of changed. So I think that's a really, really important change. It's only symbolic, but it's really significant, and it indicates something about the mindset of this government. Now, I just wanted to talk briefly about the authoritarian structure, because it's not only who's on the Commission, but it's the way that it's structured. And there's a number of changes here that are important. There's a new section 35A, which allows the Chief Executive Officer, the Chief Executive Officer is one of the new people to go on the Commission, to issue directions as to how officers are to identify serious cases of corruption. It does not seem that this direction is required to be made public, falling outside a list of matters elsewhere in the Act, which says things have to be made public. So you have this concept of somebody on the commission who's not necessarily independent actually telling the working officers of the commission that this is how you're supposed to carry out your work. And it seems to me that that's just, it's like the chief constable telling the constable that you're not supposed to arrest these people, you're only supposed to arrest these kinds of people. Now, a whole set of disciplinary powers are also handed to the chief executive officer. So, the chief executive officer can not only tell people how they're going to go about their work, the stuff how to go about their work, they can then threaten them with this whole set of disciplinary powers. They're similar to the discipline provisions in the Public Service Act. The chief executive officer is required to provide actual justice in exercising their powers. There doesn't seem to be any equivalent to appeal provisions in the Act. So there's this huge power over the staff given to the chief executive officer. A third aspect of this is that the research function of the Commission, which has been an important part of its role, that's now subject to direction by the Minister. So if you're the head of research in CCC, you set out a list of what you want to research over the next year. You send it to the Attorney General, the Attorney General sends it back with a few crosses in it and a few other things written down the bottom. And that's what you've got to research in the next year. So the actual research function of the Commission is no longer independent. It's to be directed by the Attorney General. And another interesting aspect of it, and it does go to the structure as well, is that one of the reports which was obtained last year, and which the government purports to be acting, is the Road report. And it said, look, senior officers of the Commission are hanging around too long. That's a recipe for corruption within the organisation. You hang around too long, you'll be able to be got at. But the interesting thing about this Act is that the actual commissioners, including the chairperson, has gone from a 5-year term to the possibility of 2 5-year terms. So the government can not only appoint somebody who's not independent, but that person can stay around for 10 years. So I think there's a real problem about that as well. And then another issue that I won't go into detail is that a lot of the functions which were functions of the Commission as a whole are now functions of the chairman. And so the role of the Commission itself is reduced. So it's a much more authoritarian organisation. So let's talk about the independence. And this is probably the thing that's been discussed most in the media. It's probably the thing that you've heard about the most. It's the thing that you probably understand the most. And it's probably the most important. But I do stress that those other issues, they aggravate the situation. They make it worse. So Mr. Fitzgerald's report stressed the exclusion of party political considerations and processes for the decision-making concerning criminal justice. And then the mechanism that the party leaders decided upon was that for the appointment of a commissioner, the support of at least 2 political parties within the parliamentary committee was required. It's now called bipartisan support, and that's